Welcome to This Explainer. Today, we're putting on our legal expert hats to break down the absolute monumental constitutional challenges facing Canada's newly passed Bill C-12. If you follow Canadian immigration law, you know that the landscape has just experienced a literal seismic shift. We're going to carefully analyze the mechanics of this new legislation, look at the exact Charter of Rights arguments being leveled against it, specifically under Section 7 and 15, and we'll examine the government's legal defense. Okay, let's dive right in. Consider this central, incredibly tense quote. People who arrived legally before the law existed are now told the door behind them has closed. It's a striking statement, right? It perfectly highlights the retroactive nature of the new law, and it really sets the stage for what is undoubtedly shaping up to be the most significant, heavily contested shift in Canadian refugee law since the major reforms way back in 2012. Here's our legal docket for today. We're going to methodically run through 1. The new Asylum Rulebook. 2. Section 7. The clock continues. 3. Section 15. The equality argument. 4. Section 1. The government justification. 5. Who is caught now? And finally, 6. Precedent for future claims. Part 1. The new Asylum Rulebook, establishing the facts of Bill C-12. There are a few critical dates that fundamentally alter when a person can legally make a refugee claim in Canada. Bill C-12 officially received royal assent on March 26, 2026. But the real kicker? June 24, 2020. That is the beginning of the retroactivity window. This retroactive reach, going all the way back to entries made in mid-2020, is a massive focal point for the impending litigation. Plus, looking ahead, there's a separate bar taking effect in June 2025 that specifically targets irregular border crossers. So, what are the actual mechanics here? The core rule is a hard, strict one-year cap to file a claim, and that clock starts ticking from a person's very first entry into Canada. And this part is absolutely crucial. Leaving the country and returning does not reset the clock. Let's say an international student arrived 3 years ago, went home for a summer vacation, and came back right before a war broke out in their home country. Under this rule, they're treated as having entered 3 years ago. Their window, it's already closed. Combine that with the complete bar for irregular crossers after June 2025, and you've got a drastically tightened system. Moving to Part 2, Section 7, the clock continues, focusing on life, liberty, and security. This is the absolute cornerstone of Canadian constitutional law. Charter Section 7 protects an individual's right to life, liberty, and security of the person. In Canadian jurisprudence, it's consistently held that deporting someone to a country where they face severe persecution heavily engages this section. You simply cannot deprive someone of these rights except in accordance with the principles of fundamental justice. So the constitutional dispute here brilliantly centers on a stark contrast. Historically, refugee protection in Canada was granted based on a broad assessment of the actual merits, like, is this specific person actually at a real risk of persecution? But under Bill C-12, the government is now relying on a rigid, time-based decision. The fundamental legal question, going to the courts, is this. Does deporting someone strictly because a one-year clock expired, totally regardless of the mortal danger they might face back home, align with fundamental justice? The Canadian Association of Refugee Lawyers, or CARL, and the Canadian Immigration Lawyers Association argue that it absolutely does not. Part 3, Section 15, the equality argument, and taking a look at disparate impacts. Now, Section 15 is all about ensuring equality before and under the law. It specifically protects people from discrimination based on personal characteristics, things like race, religion, and notably for this legal battle, national or ethnic origin. CARL has signaled very clearly that they're going to lean heavily on this section to argue that Bill C-12 is inherently discriminatory. Here's why. The 1951 Refugee Convention measures protection against current country conditions. And let's be real, authoritarian shifts or civil conflicts, they usually happen incredibly suddenly. The argument here is that punishing someone because a war unexpectedly broke out at home after their first year in Canada raises some massive equality red flags. These sudden geopolitical shifts aren't random. They happen in specific countries. So a hard time limit disproportionately and disparately impacts people from those specific national origin groups. This arguably violates their Section 15 equality rights right out of the gate. Which brings us to Part 4, Section 1, the government justification, which is all about combating systemic fraud. But the government isn't stepping into the courtroom without a shield. Section 1 of the Charter is the ultimate balancing act. It actually allows the government to legally restrict charter rights, like those in Section 7 and 15, but only if those limits can be demonstrably justified in a free and democratic society. The government's defense is that even if Bill C-12 does infringe on certain rights, this blunt time limit is a completely proportionate and rationally connected response to a very real pressing problem: systemic fraud. And they're bringing receipts. The government has well-documented evidence to back this up. They've got data showing organized source country brokers explicitly coaching individuals on fake narratives. They found literal document mills producing and recycling the exact same affidavit packages across multiple files, literally just swapping out the names. Plus, there are massive, statistically anomalous variations in acceptance rates by country of origin. So the government's stance is that a hard, unyielding time cap is absolutely necessary to shut down this coordinated exploitation. However, the legal community pushes back hard on this. They argue the means just don't justify the ends. Advocates point out that a rigid time limit is basically catching the slow filer, not the highly coordinated broker who already knows exactly how to game the system quickly. Instead, they propose alternative steps: implement front-end credibility hearings at the Immigration and Refugee Board, publish transparent data, and have the CBSA actively prosecute the actual brokers committing the fraud. They're essentially asking, why use a sledgehammer that punishes legitimate refugees when you could use a scalpel to target the fraud directly? Let's move to Part 5. Who is caught now? Looking at the real-world applications. Let's step out of the theoretical courtroom for a minute and look at the real people currently caught in this system. We're talking about international students and workers who have been here over a year whose home countries suddenly deteriorated, family members who arrived on temporary status before things got dangerous back home, irregular crossers after June 2025, and critically, individuals whose claims were already in motion from the early 2020s but got swept up by that retroactive clause. Carl has noted that this retroactive group presents one of the strongest factual patterns for a Section 7 violation. Now, the government might point out that these individuals aren't entirely without options, but let's look at the reality, because it is stark. For those caught by the time limit, the only remaining option is the Pre-Removal Risk Assessment, or PRRA. The old baseline, a full refugee hearing, allowed for a really broad assessment of persecution, with a historically higher acceptance rate. But the new reality, the PRRA, has a significantly narrower legal test and a much, much lower historical acceptance rate. It's the only safety net left, but the holes in that net are huge. Finally, Part 6, Precedent for Future Claims, and the 12 to 18-month horizon. So, what does this all mean for the future of Canadian immigration law? Because of the sheer volume of cases, the federal court recently grouped roughly 36 separate constitutional challenges together. This means one judge will coordinate the shared legal questions. We are looking at a solid 12 to 18 months before oral hearings and a real decision are reached. And honestly, no matter who wins at the federal court, appeals all the way to the Supreme Court of Canada are highly likely. But remember, during this entire multi-year process, Bill C-12 remains strictly in force. How the courts interpret Sections 7 and 15 here is absolutely crucial, because it will literally write the rulebook for all future asylum seekers. As this landmark litigation unfolds, it leaves us asking a profound question. Will the courts decide that a blunt time limit is a proportionate weapon against systemic fraud? Or does deporting individuals based on an expired clock, rather than the actual merits of their danger, fundamentally violate the life, liberty, and equality guarantees of the Canadian Charter of Rights? How Canada balances the integrity of its system with the fundamental justice owed to those seeking refuge is something we're going to be watching very, very closely. Thank you so much for joining me for this explainer, and keep an eye on the courts. The legal battle has only just begun.